Good morning, everybody. Welcome to our presentation on brief focused assessments. I want to thank Dr. Jeff Klein for the invitation to do this presentation. Also want to thank him for all the hard work he's done over the last several years putting together these trainings. This presentation is a version of what we will present on June 3rd at the Association of Family and Conciliation Courts 60th International Conference in Los Angeles. My name is Ken Perlmutter. I am a licensed psychologist in the state of California, and my practice has focused for almost 40 years now on child custody forensic matters. I first presented on BFAs at the AFCC 50th conference in 2013. You have all the materials from that presentation in your handouts. What we have done is to update and explain everything that has occurred since then, and we will teach you today about the current state of BFAs. I'm honored to do this presentation with my esteemed colleague, Christy Bradshaw Schmidt, who I've been working with on this project for over a year and a half, who has done a great amount of work advancing BFAs in Texas.
Thank you, Ken. And I want to just reiterate what Ken said. We appreciate y'all being here. I certainly am honored and appreciate the opportunity to be a part of this presentation. I'm a licensed professional counselor. I've been doing child custody evaluations in what we didn't call BFAs, but were BFAs since 2020. So I've been doing this 23 years, and I'm excited to be here with y'all today. So looking at what we're going to talk about today is, and you've got all your slides and you have all your information in your packet. So if I have a technical difficulty of not being able to reverse my slides, I apologize. So let's talk about our learning objectives today. We're going to learn and identify the differences between a child custody evaluation and a brief focused assessment, because they really are two different animals. We're also going to talk about how to do a BFA, and Ken's going to give us some great information kind of from beginning to end, looking at when they're appropriate, when they're not appropriate, what are the tips and tricks and pitfalls that you need to avoid so that you can have an understanding of how to take these vital assessments back into your community and have them be a new resource if it doesn't already exist for the families that you serve. We're also going to look at the AFCC guidelines for brief focused assessments, as well as possible court orders for you to consider utilizing in your jurisdiction. Now, we've only got an hour. We have a lot of material. You have on our over 260 pages of articles and data and resources that we have compiled, including a survey that we did in preparation for this presentation. So if we skip forward a little bit or have a little bit of technical difficulties as we go through the slides, you have everything in your packet. Please just utilize that, and you will hear us say probably more than once in this presentation, we are open to your considerations, your suggestions, and to being available to you to help. So don't hesitate to reach out. And of course, we'll look forward to questions today live at 3:30. But Ken, you want to talk about the limitations of our presentation?
Absolutely. So when I came up with the idea of doing BFAs, and it wasn't my idea, in 2009, as you'll learn, AFCC published the guidelines for BFAs, and I was taken with this idea, and I discussed this with a colleague of mine, Judge Rick Dubois, and he told me that he wanted me to get on this project. And he basically said, from his perspective, that we didn't need any local rules. He didn't care about statutory limitations, but he thought this was such a valuable process that if I could get it going, that he would endorse it. We know in the real world, and we especially know this now, and Christy will say a bit about the hurdles in Texas, that it really depends on what the rules are and what the laws are in your jurisdiction. So if you haven't done BFAs where you live, that's something you truly need to investigate and make sure you're on the same page. But back to 2010, what Judge Dubois told me was write up a protocol, and you have not the original protocol, but there were several versions of the protocol, and you have the latest version from 2013, which still exists and is still used in San Mateo County, California. So that, we'll talk about the work in a few minutes, but that could be a good template for you to adjust and use in your own jurisdiction. And then finally, the concern at the very beginning was, would we be able to explain this in a way that attorneys could understand that this was a briefer model, and as this brand new concept came out, we had to manage expectations. So one of the things that we realized in preparing for this workshop is, on the slide, you'll see these are all the different monikers that were used to describe a BFA. And when I was investigating this in terms of what was going on in other states, I found not only did they have different words for labels, but also that their processes were somewhat different. I was encouraged to find that the core of this was, we're going to look at 2 or 3 very specific questions and provide information to the decision makers in a new way. So at the very beginning, I followed very strictly the 2009 AFCC guidelines for BFAs.
So if we look at the relevant literature related to BFAs, what Ken and I have found is there's not a lot. There's just not a lot that focuses on this concept specifically. There was an article published in the Family Court Review in 2012 in relation to the guidelines for BFA that the AFCC passed. And so that article is available to you in your handouts. There's, I think, hopefully for all of us who work with court-involved families, we're familiar with the Parenting Plan Evaluations book that's now on its 2nd edition. And if you work with court-involved families, it's a great resource to have in your library because it has access to a great deal of the literature that addresses a lot of the issues that you are able to look at in a BFA. There's also Ken's article from his San Mateo County pilot project that he's going to talk a little bit more about as well. And then there's an article that I wrote with Dr. Saul Rappaport. We were the primary authors, related to a presentation that we did last year in Chicago for a Texas crowd that led to my meeting Ken and where we are today. So that article is also contained in your handouts, and that discusses the Texas model that I'll be talking a little bit more about as we go along. So Ken, you want to share about the history of how we've gotten here?
Sure. I guess the main point is we learned from the history, and as we enter into what I really believe is now the true phase of doing BFAs, there are things to learn from the history. So the key event was in 2009, the publishing of the guidelines. And I don't think, from what I investigated in 2010, that it was adopted by many other jurisdictions around the country. And certainly in California, it was not adopted. Nobody else was doing any work at that point in time. So after the first study in 2012, which we'll talk about in the next few slides, that's what led to the data about how they were being done and how they were being received. And that led to the workshop in 2013. And at that point, a very key event was in 2014, when I was working a great deal after getting this started in San Mateo County. I worked with the judiciary in Santa Clara County. And by 2014, we developed Form 1127, which you'll see in a later slide, that was the attachment to the order for child custody evaluations. And you'll see that that lists about 20 areas of focus. Now, one thing that's pretty interesting is from about 2016 to 2020, it seemed in California, and I was not tracking other parts of the country, that there were not a lot of BFAs being done. We don't know the exact reason, but I think it has to do with there was no continuing education to teach people how to do BFAs. My input on helping people do BFAs was limited in that it was limited to individual consultations with people who wanted to do it. There was no publicity about, excuse me, about BFAs at AFCC conferences. There was no revision of the guidelines. And then at the point of the beginning of the pandemic in 2020, a key event, which Christy will talk about, is our colleague, Dr. Tammy Axelson, did a very large survey of judges across the country on child custody evaluations. And that had some incredibly relevant data for BFAs. And then finally, which we'll talk about later this morning, was the new BFA survey that Christy and I have done, which has given us some really important information. I think I just did that. All right.
And these you can find on the AFCC website.
Right. And here's where it all started. And I think, as I know you can't go back, right? All right.
Sorry.
So I just want to say a couple words about the guideline. I think it's very instructive to read that document now. As I look at it now, it still has a big impact on me when I look at what it was trying to do. And it was truly a sea change in the field of doing child custody evaluations. And so even though it doesn't equal a child custody evaluation, it is still an evaluative procedure. A CCE and a BFA are both referred to as an evaluative procedure. I'm happy to say that the guidelines are awaiting revision. And I think that means in the near future that we're going to see some new guidelines. From my perspective, it's going to be very interesting, and it remains unclear about how any new BFA guidelines will be integrated with the brand new 2022 Guidelines for Parenting Plan Evaluations in Family Law Cases. And this is the current AFCC state of the art about how to do child custody evaluations, which clearly the nomenclature now is parenting plan evaluations. All right. So I'm going to talk briefly about the original survey on BFAs. So all of this is what led to the article you have. And this describes the pilot project that I did, in which, and this process of what I did is relevant to now. It's relevant and a teaching moment for people in other jurisdictions about how to form a basis to start to get these done. So I came up with an initial very experimental protocol, and I disseminated it to mental health professionals, attorneys, judges, and family court services. And I got feedback from all of them. I actually went out and met with these people, and I actually did trainings, and I did brown bag lunches, and I basically spoke to anyone who would listen to me, and those were well received. And so by late 2010, people were doing BFAs in San Mateo County. And in 2012, I then came up with the very first survey. And this survey was totally focused on the implementation of BFAs. And on the last slide and on this slide, you have a good description of what we did. And even at the time, it didn't seem like a large number of people. In retrospect, 22 attorneys, 6 mediators, 2 judges, and 20 mental health professionals was a pretty robust number of people who then took the survey over the course of a year and a half. And at that point in time, I got a very robust response with 21 of the surveys completed. So the findings: attorneys were using BFAs. Now, one of the things we're going to talk about a lot is, even though it was an issue then, it's still an issue now. And that has to do with educating the decision makers, the users, the clientele, that this is not a child custody evaluation. And it requires that the BFA have a very clear focus. And I used to get phone calls from mental health professionals asking me what to do because the focus was not clear. And that later informed, and we'll talk a bit about this, the final version of the protocol. A key event at that point in time was that FCS mediators in San Mateo County, which is a recommending county, meaning they can make recommendations after mediation, found this was a great option for them to use in situations where they were not able to reach a full agreement, but they didn't feel a full evaluation was needed, and they could specifically recommend a BFA with 1, 2, or 3 areas of focus. That those people were very pleased at that point in time. I got a list of 20 mental health professionals who were willing to do BFAs, and I disseminated that list a couple of different ways, to the judges, to the attorneys, and to an online listing on the Santa Clara County Psychological Association website. And what was very notable is that 2 judges, Judge Dubois and one of his colleagues, over a year and a half, had asked for BFAs in about 37 matters. All right. As I said, the mediators were quite enamored of this intervention assessment technique. So we definitely were able to conclude that this new methodology was embraced by all, and that we saw the beginning growing pains of a new concept and a new methodology. We had to look at questions such as how to do them, how to train people to do them, how to have them ordered by the court, and then when we had the results, how to use them. The early data indicated that the results were very helpful, and that they were very helpful to clients to comprehend rather than a long drawn out child custody evaluation. There was clear evidence that the judges found these to be of great assistance and they embraced them. I guess the key point on this slide is that we thought about, actually two key points. We thought about a possible need for changing the local rules, but we didn't. And as it exists now, there is no local rule in San Mateo County. But what this did was, when I then started to do the work in Santa Clara County, it helped us to hone in on what the local rule needed to be. And then this is where we started to think about offering a reduced fee option, which we didn't do in San Mateo County, but we would eventually do in Santa Clara County. I couldn't believe that in doing the slides, Christy found this map. And I would like to say that I had nothing to do with the slides. So Christy gets all the credit for the amazing slides that you're going to see. And so now we're in Santa Clara County, as people who are at this presentation, the virtual presentation, know. These two counties are adjacent, very different populations. Santa Clara County is much larger, but we had the base because a lot of the professionals in Santa Clara County work in San Mateo County. And so I did my second survey. I've become really good at doing surveys over the years. And this one showed that 31 BFAs were started and completed in that 2-year period by 10 mental health professionals. And one of the agreements I had made with the judges was that, and I think you can go to the next slide, was that in order to publicize the BFA and to use the BFA, they wanted me to get mental health professionals to do this at 3 different levels of fees: the regular fee, a flat fee, and then a reduced fee. And we were smart enough to figure out that in order to get one of the 2 lower tier, that the judge needed to order that tier would be in place. As we look back on it, we were pretty surprised that despite the publicity we had on that, not a lot of people were using the reduced fee. This is still an issue that professionals struggle with now, not only in BFAs, but in child custody evaluations. I personally still believe that the BFA, because it takes less time, is better suited for different fee options.
Okay, so if we shift gear and look at how this is relevant today, based upon all the work that Ken did leading up to where we sit today, one of the things that was very interesting when Ken and I started working together is at the same time that we were working on BFAs and our discussions and getting up to speed together, I have a colleague by the name of Dr. Tammy Axelson, who is working on her PhD final project, which was to draft and ultimately have published an article entitled "Are Child Custody Evaluations Beneficial to Family Law Matters?" She worked on this with Jennifer Gentile out of Chicago, and this is in the process of being published as we speak by Family Court Review through AFCC. This is a replication study of a previous study done of judges in one state, which I believe was Michigan. It was less than 100 judges who were surveyed, but was only regarding that state. And so this study took that original study, and we now have a product that contains 268 judges surveys throughout 42 states related to their view of child custody evaluations. And what was interesting from Tammy's study is that some of her findings lead us to believe that BFAs absolutely have a place throughout our country for the families that we serve. The information that she found and the data that she constructed basically told us that they think they're too expensive, which I think we've probably all heard. They think they should be completed in 3 months or less, which I think we all agree with, but if we had, it would be a lot easier to do that if there were more of us, which seems to be a problem, I think, nationwide. They take too long to do, which is a consistent complaint I hear where I practice. And they really don't want the long, detailed reports. They really want a summary of that information. And that in turn leads us to believe that BFAs really do have a place in the counties where we work, the states where we work, and for the families that we serve. So, Ken, let's talk a little bit about exactly what is a brief focused assessment.
A brief focused assessment is a court-ordered evaluative process that is narrow in scope and looks specifically at 1, 2, or 3 focus areas.
What about the purpose?
The purpose is to provide the decision makers, one of which is the judge, with information that has been produced through reliable evaluative procedures. This second point is key. The BFA process, it's key and it has some really important implications. It's descriptive rather than analytic. And so what that means, and it was clear in the 2009 guidelines that the great thinkers who put that together were very clear on this important part. And so it describes what's going on in a family about a very specific issue. And it does not delve into long analytic processes. What it does is it seeks to get answers to these questions and then provide that information to the decision makers, which will allow attorneys and parents to potentially agree. And also, if it does get to the court, it provides judges with a great deal of information compared to if they were just listening to the arguments from attorneys and testimony by parents. We know, and this is just simply a function of what a BFA is and what it does, is that it allows only for limited inferences. So we're not talking about the type of cases, and we'll give you examples in a few minutes, that need a full child custody evaluation. So these are the one thing that I was immediately enamored of by a BFA was that compared to a child custody evaluation that must include, and in California, the rules of court specifically state what needs to happen in a child custody evaluation. But in a BFA, the beauty of it is I got to tailor what I would do in the BFA based on what the problems were. And so these different examples on the left are things that may happen. I've done several BFAs where I never even interviewed a child. And that's a wonderful situation where children don't need to be in a process that could be stressful for them. And then finally, as we've referred to, and as we will refer to, these foci, this focus needs to be clearly stated in the appointment order.
So let's look at what a brief focus is not. And the biggest thing is it's not a comprehensive child custody evaluation, as Ken said. It's also not an opportunity to backdoor a child custody evaluation. And we're going to talk in a little bit about the need for controlling the process and being in charge of that process so that parents or attorneys don't utilize a BFA in an attempt to backdoor a child custody evaluation, because it can be very tempting because they always want to do more with less. This is also not a general focus of the family in an assessment. You're not looking at overarching parent functioning or co-parenting functioning. You're not looking at the needs of the child and comparing each parent's strengths and weaknesses as parents and co-parents to the needs of that child for a potential recommendation. That's not what this process entails. And as Ken said, this is not about examining broader issues. That's not the purpose of it. So let's look at what are some of the appropriate issues for a BFA. And I'm not going to go through all of these because we all know y'all can read, but I want to hit some high points. One is the child's voice and the child's preference. If I look back in my career, this is a large part of the BFAs that I did because I came out of a family court services environment, and we interview children on a regular basis for the judges. Sometimes that was for their preference. That was one of the questions that was asked. Sometimes it was strictly just to get information from the child, but that was a very quick interview and a turnaround of a report, oftentimes in as little as a day, to get the court information almost on an immediate basis to be able to make some usually temporary orders for those families. So that's one way. And there's some argument on whether or not resist refuse dynamics can be used as a BFA. I would argue that this is a great place to use them as long as we're not making parenting plan recommendations. Because we all know, for those who work with these families who struggle with parent-child contact problems, that time's the enemy. We have to get in and get appropriate resources to this family in order to present a cutoff between that parent and that child. And a BFA can go in, look at the therapy that's been done or not done, the interventions that have worked or not worked, and make a treatment plan recommendation to the court to get that family into the process of hopefully moving forward and repairing some of those parent-child contact problems that exist. It'd be no different than going in and doing a BFA to look at whether a parent or a child needs therapeutic intervention for some reason. So I really think there's a place for that with some of these most complex and difficult cases that we're seeing. And then obviously there's the whole, do we have a substance abuse issue or a mental health issue? That's basically a psych eval or a substance abuse eval that can be seen as a BFA, and then a home visit. What a quick way to make sure, if you've got concerns as whether or not a parent's hoarding, to go out, make sure you're at the right house and they haven't said that they live somewhere else than where they actually live. But that's a quick go see the house, make a report to the court, and that gives the court information to make an immediate decision for that family in the moment to hopefully help them in the process of where their litigation is and to get them to the finish line in relation to their case. So there's a number of ways that brief focused assessments can be utilized. Ken, what's not appropriate for a BFA?
So we were pretty clear about this from early on, that these are 6 good examples of situations that were only going to be amenable to a child custody evaluation. So for example, a family that is recently dissolved, and this is not mediation, where they may have a temporary plan, but in order to assess the family and their individual functioning and their functioning as a system, and then look at the needs of everybody and look at the concerns of the parents, it just wasn't ever going to work to do this in a brief model. Similarly for relocation. Relocation child custody evaluations are unique. They require intensive work. They require extensive interviews. They frequently will require a home visit locally, and they may at times require a visit to the area where the parent requests to move the children. So intimate partner violence, clearly something that's very complex, that requires a great deal of work. So we're not only looking at complex ideas, but we were looking at matters that would involve a lot of time. Our goal, laughably in a way, our goal in the very beginning was to do these BFAs in 15 to 20 hours. I think there's another slide later where we'll talk about how that's changed. But still, I think there is data that BFAs are done expeditiously and are able to be done in a short period of time for a lower cost. So the one thing I want to say about this slide, and I think we'll reiterate it again, is that it's incumbent on the evaluator that if they have attorneys that want them to look at these kinds of issues, that they need to decline and try to work it with the attorneys. And if they can't work it out with the attorneys, then to have a telephonic case management conference with the judge so that the judge can weigh in on it.
And the key in deciding when a BFA is appropriate and when it's not is really jurisdictional in nature. You need to know, does your law allow it? California is similar to Texas. We modeled our child custody evaluation statute after y'all. So there are strict guidelines for what has to be done. So does your law allow a BFA? And if so, in what capacity? Which is why the Texas model has been a little finessed and changed because of the laws that we have. But you also need to know, will your judge and your judiciary use it? And the one thing I think Ken and I would both agree on, and you'll probably hear us say more than once, it really becomes our job to get out and educate our bar and our judiciary on this service so that they know that it's available to the families that they serve. So Ken, what are the advantages of a BFA?
Sure. We'd like to get these done in 30 to 60 days. As most people know, evaluations can take 4 to 6 months, if not longer. There's no reason, absent a lack of cooperation from parents, to not do these BFAs in a very brief period of time. As I said previously, it's less intrusive to the family. It requires minimal involvement of children, if not at all. And again, as I said about the amount of time, we don't want evaluators, BFA evaluators, to give these things away. We want evaluators to get paid their fair fee. And in this model, we present them with a way to do them quicker. And also a key, and I don't remember if there's a slide on this, is that, I think there is, these reports are shorter, they're less time consuming. A full CCE report could take 25, 30 hours. These reports can typically be done in 5 to 10 hours. And actually, I will say more about that later.
So as far as the limitations to a BFA, it's some of the things we've already covered. We are only allowed to give limited interpretations and opinions. Oftentimes, we're not allowed to make parenting time recommendations unless everything in your law has been done. I know that's the case where I practice in Texas. So we are limited in what we can and cannot say. And it's a limited scope. And we don't have the ability, or we should not be tempted to go explore any new issues that we uncover. We certainly should list them and let the court know that those issues exist, but those are not areas for us to continue down the path of investigating. We're all helpers. We all want to help often and figure things out, but that's not the role of a BFA. So it's really important that we control that process. We know our role, we know the scope of our role, and we stay in our lane when we're doing a BFA and not allow ourselves to start drifting towards what may look like more of a child custody evaluation. And one of the things that Ken and I wanted to touch on was also the diversity, equity, and inclusion, which I think Ken had taught me the new word is belonging, which I love. But one of the things that BFAs really allow for is they allow underserved communities access to justice. We all know how much custody evaluations can cost in certain communities. We all know that there's a number of families who cannot afford that. And BFAs really provide an opportunity for there to be an assessment of the immediate needs of the family on a limited basis based upon the specific focused questions posed by the court, and still give those families access to services that help them in their litigation, help their children, and hopefully help the judge or them make good decisions for their children going forward after a separation or divorce. The other thing that was interesting when we started in Texas working on the presentation I did last May is Judge Hofstadler, who I presented with during my presentation, went, apparently I've been doing these in rural communities in Texas forever and didn't know what they were, because they deal with that where there's not a lot of money or their dockets are just overloaded. And they were actually asking for just certain pieces of custody evaluations to be done and didn't realize that what they were ultimately ordering was a BFA. But this really has the potential to serve those communities that may be underserved or just not have the finances to and access to resources that families with more financial means have. And so I think that's really important for us to remember.
So we're going to talk again about the initial phone conference with the attorneys, and that's key in any evaluation approach, that we as mental health professionals need to listen carefully to what the questions are. And in my practice, typically about half of the cases that come to me, they'll already say what the focus is. And in some cases, I help them determine what the focus is. And in those cases, sometimes I'll say, it's not appropriate for a BFA. So it's got to be narrow, it's got to be discrete, it's got to be focused. And here's where we get into the education part. And that's why in San Mateo County, it was very helpful. I could just send them a copy of the protocol. The one thing that the mental health professional needs to think about is, are they going to be able to describe these results succinctly and not get into complex concepts that require more in-depth analysis?
So looking at the Texas model, and you can read the paper that we wrote that goes into detail of this, but when we compare the AFCC guidelines for brief focused assessment to the family code where I practice in Texas, we had problems because of the limitations on the ability to make what we term possession and access recommendations or parenting time recommendations. And so we were trying to figure out how to take the guidelines and all of the positive things that BFAs offer to families, and how can we address all of the different topics and all of the different types of cases that we see in a brief focused way while still complying with our law. And so what that led to is we created a number of questions to be answered that don't provide a parenting time recommendation, but it gets just up to the line enough that a judge is able to say, okay, I know exactly what you're telling me, I understand what you're telling me, but it's all about making sure that the questions that they're posing to us are questions, number one, that we can answer, and number two, don't allow us to cross the line and violate our law or our statute. So there are ways to address a number of different issues through a BFA if we get creative and we look at different ways to ask questions about the issues to provide the court as much information as possible to help the judge in making the decision that's best for those children involved. So how do we get referrals for BFAs, Ken?
The key is you got to do a lot of child custody evaluations. And that sort of experience is one that helps you understand what the limitations are of a BFA and what the reductive process of a BFA is really about. It raises the question of, how does a newbie who's just learning to do a child custody evaluation do a BFA? I would argue that for someone who's just starting out, and as I believe most people know, that in order to qualify to be a child custody evaluator, you need to have done or materially assisted 4 evaluations within a 3-year period of time. And so if you can get a supervisor who's skilled in doing BFAs, it's a great experience to have one of those be a BFA. In order to get more referrals, you need to be known to judges and attorneys. You need to be willing to speak to family law groups on your practice and on BFAs, and continue to educate the public. over my entire career, I never had a website. And 2 years ago, I did a website. And it was very helpful because I clearly differentiate between a CCE and a BFA. And I go through the processes. So I use that kind of as a brochure, and I have people read it and they can see in black and white exactly what the differences are.
Okay, so you've triaged your cases we talked about. We've looked at what a BFA is. We decided that's what we need. Now, what do we do? Ken's already talked about this. If you're an attorney, you need to identify a qualified provider. And from the very beginning, when Ken and I spoke, we both agreed you need to be fully trained in doing custody evaluations to do BFAs. You can't, you need to know how to build the mothership in order to know how to build the dinghy to get to land. So it's really important that somebody knows how to do a full-blown custody evaluation in those interviews and acquiring that data and assessing that data and knowing how to limit that based upon the referral questions you're asked. So we really think you need to be fully qualified to do custody evaluations in order to do BFAs as well. If you're an MHP, we highly recommend that you do an initial phone call with the attorneys, preferably with them both on the phone at the same time. So you can talk about the case and ensure that it meets what is needed for a BFA, and that they're not asking you to get outside the scope of that role. And you want the attorneys to hear the same thing. So you want to talk about that. You then want to ensure that there's a solid order, which you have a number of sample orders in your material. And Ken's going to talk about one of the specific orders here in just a minute. But you also want to expedite the process, and you want to prepare your client. You want to make sure that the clients know what to expect, that they are aware that this is just a BFA. It's not a full-blown custody evaluations. They need to know that it's going to look different from what they may have heard a child custody evaluation was. And they need to be prepared to know what they can and cannot provide you so that they don't attempt to push you out of your lane. Within that initial phone call, as we've discussed already, you'll need to align on the 2 to 3 issues that are going to be addressed. Make sure the attorneys understand the expectations, not the clients, but the lawyers as well. Make sure that there are questions you can answer. My favorite question I've had somebody send me in an order was on a scale of 1 to 10. And I'm like, I don't know of any research that allows me to answer anything on a scale of 1 to 10. And attorneys think differently from mental health professionals and vice versa. So collaborating on those questions, make sure it gets asked in a way that's helpful to the court, but also something that we can actually answer. And then we need to make sure on that phone call that we do a detailed query to ensure that it qualifies as a BFA, as Ken said, before you proceed down the path of getting into a case and realizing this probably should have been a full-blown child custody evaluation. So let's look at the orders real quick. Ken?
Yeah, so 2 of the most important takeaways from today for starting to do your own and learning about what qualifies as a BFA are the San Mateo County protocol, which has a good 20 to 25 examples of things that are appropriate, and it has a good 10 examples of things that are not appropriate. And then this is the document that came in 2014. This is the attachment to the order, and you should look at this pretty carefully. At the very bottom, which you can't see on the slide, except it says it's item 2P as in Peter, and it's already X'd out. And that basically says the evaluator can address any other areas that address the health, safety, welfare, and best interests of the child. So that's key. That's something, again, we'll talk about a little bit later. And this is all the legal mumbo jumbo. This gives you an example of what needs to happen within the jurisdiction in order to be able to do the BFA.
So we have about 10 minutes left. So Ken, let's look at, tell us about the best practices for brief focused assessment.
All right. Slide 39, correct?
38.
Sorry about that.
No worries.
Okay. So I'm not going to read these. I think everybody can read them, and based on everything that we've been talking about so far, this goes back, especially the last one, that you can't let it become a custody evaluation. It goes back to if it should be absolutely clear to the BFA evaluator after the first interviews that everything is on track. And the bottom line is, if it's not on track, consult with the attorneys. And if it doesn't work with the attorneys, then got to talk to the judge. 39. These are the expectations. So even though we said we think they could be done in 30 to 60 days, we want to make sure that everybody knows what the process is. It should be clear to attorneys and parents that we expect this will be a briefer process, but none of that matters if the BFA evaluator does not keep the clients informed on the process. And one of the things I realized in my practice early on is that I give regular updates from after the first interviews until the final interview of where I'm at in the process and what my timeline is. And then, of course, the key is that giving very specific answers to the referral questions.
So as far as the key pitfalls, it's just kind of the reverse of that. If you fail to get good referral questions and get the scope of the BFA, then you can end up in a situation where you are down a slippery slope into a full-blown custody evaluation. I have a colleague, Dr. Susan Fletcher, that says what you do on the front end protects you on the back end. So getting a good order with good referral questions that clearly defines the scope of what the court is wanting from you can be very, very helpful to avoiding getting off track from those things. And the other thing is you have to control the process, and you have to be sure that you don't allow it to get off track, either by the parties, by the attorneys, or even by the data that you're acquiring. All of those things can pull you off track if you let it. So it really has to be your process that you're in charge of, and knowing that if there are additional issues to be addressed, how to do that without it taking your BFA off course. So what do you do if it gets off track, Ken?
Why don't you go to the next slide and I will tell you. So it really depends on this one. I mean, there's two sub issues here. In the protocol, we said that so there's two kinds of other issues. One are other issues that are not emergent. And for that, it could be a section in the report that simply stays something like, these issues were discovered, it's new, it's different, and it's something that the court may consider examining in the future. That would be something like, you're looking at a particular issue and there's data that indicates that maybe a child has ADD, and nobody's ever brought that up. So you can describe that and say that that's something that perhaps needs to get looked at. And as we said, it can always be addressed if it's an emergent issue, and then it has to do with the health, safety, welfare, and best interests. And these would be things like child abuse or a new DV allegation. And then it's a judgment call. And you may need to make a formal report. You may need to conference with the attorneys, and again, conference with the judge. But everything can be handled appropriately.
So we've got about 5 minutes left, so we're going to move very quickly through this. But one of the things that Ken and I did during the course of the process of working on this presentation was we did an updated survey, and we polled people from all over the area, both custody evaluators, attorneys, and judges. and you can go through the slides yourself. You also have an entire copy of the survey in your packet of material with all of the results and answers that we received from everybody who participated. But we want to talk very quickly just about the findings. So Ken, do you want to talk about what we learned from the comparison of CCEs to BFAs?
Yes, this is an outstanding result, and I encourage you to look at this slide later. This slide means to Christy and I that not only are BFAs done, but they're being done appropriately. And it lines up with the CCEs. And these are what we've been teaching you about what is appropriate for a BFA and what is appropriate for a CCE. Why don't you go to the next slide? I want to make a plug for, and this is for California, that first item about increasing training. So you should note that on this and subsequent slide, these were individual comments from individual respondents. And we are still processing all of this. But AFCC California has a mentorship outreach committee in which we are guiding people who want to be child custody evaluators about the process. We're providing training opportunities. For example, next October, we're having a 2-day training workshop on topics for new evaluators. And this is just the way to get to the future of having new and experienced people do this work. We don't have time to get into what we, in this committee, we identify as the aging out of the population of evaluators and assessors. And so we really need to encourage new and younger people, and we're actively doing that and recruiting people.
You're going to notice, and we're going to skip through these. I want to make sure Ken has a chance to talk about the future of BFAs with about the little less than 3 minutes that we have left. But we do have a number of responses that are on your slides that you have in your material, as well as in your packet, related to what everyone had to say about suggestions for improving BFAs. And we also did a detailed look from the bench and from the bar, what attorneys had to share with evaluators. And they had a lot of very interesting opinions, as you can imagine, that are helpful, and most of them are unexpected. But if you scroll through those and you get to the last one, I like the fact, just to end on a positive, that I'd like them to know we're thankful for their work, and we know how hard their job is. And we often don't get pats on the back. So we wanted to end that on a positive note, and y'all can certainly review that. But Ken, if we go forward to slide 55, talk a little bit in our last little bit about what you see the future considerations to be for BFAs.
Absolutely. So 3 main points. One is that we need to do more and make a bigger outreach to judges and attorneys. That's pretty clear. And it's back to the future. It's the same thing that I did from 2010 to 2013. And I often pride myself in that, for example, Santa Clara County, I may know a couple of the 20 judges compared to in 2010 when I knew all of the judges. We need to figure out a way to do trainings, nuts and bolts and advanced trainings through AFCC. We don't know that there's a market to do that. And then we need to do more grassroots work in the local jurisdictions that don't have BFAs and encourage them to do them. A side note, the other day I was looking at the local rule for child custody evaluations in Santa Clara County, and it uses the words child custody evaluation and BFAs. So to me, like, that was just great. It was just wonderful. And finally, I would like to say it's sort of hard for me to believe that this project started in 2010 And I have very clear memories about that first workshop in 2013, which I relived with Christy when we presented at AFCC in early June. And it feels to me like now we're really ready to start with BFAs in a much different way. So it's been humbling for me to have this experience and be involved in propagating it, because I believe that it is absolutely crucial to the future of mental health professionals in family law.
And just to conclude, like I said, we are here. Ken and I are both responsive and open to suggestions and considerations and continuing the conversation. And we will look forward to seeing you at 3:30 for any of you who have any questions.
And not only are we available by email, but if you go to our websites, you'll also find our phone numbers. And we're very generous with our time to help anybody who's interested in doing more and learning more about BFAs. So thank you again, everybody. See you later.